This is Rehan Alimohammad, and this is another edition of Do You Know the Laws, brought to you by Rehan Alimohammad PC. Today we're going to be talking about wills. It's very important for everyone to have a will. A lot of people believe that they don't have enough assets and everything is in their spouse's name, or whatever the reason or excuse may be not to have a will. It's not good enough. Because if you do not have a will, the cost that it would take your beneficiaries or your family members to change things from your name to their name or pass things down is going to be substantially higher and may not happen at all if you don't have a will. So it's very important to have a will. There's a lot of do-it-yourself wills out there on certain websites, but it's very important to have the will done by an attorney or at least reviewed by an attorney, because what happens is if the will is done and it's not a proper will and it doesn't meet all the formalities, then once you pass away, you cannot change the will at that point. And then they're going to have to go through possibly expensive procedures like the small estate affidavit and things like that, just to do what should have been done with the will. So today we're going to talk about a will and a couple other documents that are very important for you to do. But again, this type of law is state-specific, so every state has their own rules, and you need to check with an attorney who's licensed to practice in your state. First of all, with the will, if you do not have a will, it doesn't mean that your property passes to the state. That's what a lot of people believe. But again, it may pass to someone that you do not wish for it to pass to, or in the percentage that it does pass to, you want to pick another percentage. The only way to do that is through a will. There's no such thing as a joint will between husband and wife. You need to have your own separate will, and you need to have it in a place that's accessible to someone after you pass away. There are counties around the country that allow you to record your will. It doesn't cost that much, and your will does not become public record until you pass away. So that's a good place to put the original will, and I would not put it in a safety deposit box, because after you pass away, who's going to be able to get into that is very limited. So with married couples, it's important to know whether you're in a community property state. Your will does not dispose of any property that is held by your spouse. So for example, if you're in a community property state and you own a house jointly, or you bought the house while you were married and it is community property, then leaving the house in your will only leaves your share of the house, which is half, to whoever your beneficiary is, and the other half is still owned by your spouse if they survive you. Or if they don't survive you, then it is controlled by their will. So it's very important to know, first of all, when you're in a community property state, and to understand what is community property and what isn't. For example, most rules indicate that what is accumulated during marriage is community property. What is gifted during the marriage or inherited or is owned before the marriage is separate property. So you need to be familiar with that. In the will, you can also do something very important. If you have minor children, you can appoint a guardian in the will. So, for example, if you don't have a will, the court may choose who the guardian is going to be for your children, and that's a very important decision that obviously you want to make that on your own. Let's see. It's important to have a will, update your will. When you create a second will and you have the first one, there's standard language in the second will that says any will before this is revoked. So it's not like you're going to have two wills unless you create what's called a codicil to the original will. You should revise your will and you should review your will every time you have a life change. For example, marriage, divorce, new children, someone passes away in your immediate family or one of your beneficiaries. Because if you do not revise it, then what I've seen is some very drastic results. For example, somebody is divorced and they did not change their will, they pass away, and the new spouse is fighting with the old spouse as far as who gets what property, or children for that matter. So you need to make sure that you revise your will at the appropriate times. You need to, depending on the state, you need to probate the will after you have passed away within a certain amount of time. Probate is basically what's known as the legal process for administering the estate and resolving all the claims to the property. So you need to do that. For example, if you left your property to your spouse and they have your will, and the deed to the house says it's owned by Mr. Smith and Mrs. Smith. Mr. Smith passes away. Mr. Smith left a will leaving his half to Mrs. Smith, but Mrs. Smith 10 years later, 15 years later has never probated the will. Well, when she tries to sell the property, the deed still says Mr. and Mrs. Smith, and who's going to sign off on that sale as Mr. Smith? So you need to make sure that you probate, obviously, within a certain amount of time, and there are exceptions to the rule, but you need to make sure that you probate the will. The executor is a personal representative, a person who you appoint in your will to read your will and decide, according to what the will says, who to give certain properties to. They can be reimbursed for their expenses. They may have to post a bond depending on what you write in your will. So it's very important that you choose your executor. Your executor may or may not be a beneficiary of your will. It doesn't really matter. It can be a friend of yours, a brother or sister. It does not mean just because they are an executor that they're going to get something from your estate. A durable power of attorney is something that is done beforehand, while you're still alive, and basically it appoints an agent to undertake certain business decisions for you, or personal decisions as far as certain properties. They may be authorized to sell, borrow in your name. So it's very important to understand always what you're signing. You don't want to be caught off guard and sign something and then later on something is done to a lot of your property that you weren't aware was going to happen. A medical power of attorney is a document whereby you can appoint an agent to make certain medical decisions for you if you're unable to do that. A living will is a document that tells the doctor if you want to be, even in a terminal condition, to be kept alive using a machine, for lack of a better word. So those are certain documents that I would also consider creating when you create the will. So you need to make sure that, number one, you do get a will. Everybody needs to get a will. Husband and wife need to get separate wills. There's no such thing as a joint will. And make sure that you think through your decisions on who you're going to leave certain things to, and make sure the will is done properly and reviewed by an attorney, and it's done and it's modified when you need to modify. It's redone when you need to remake it because of a life change such as divorce or marriage, something like that, because you don't want to have a old will and then something happens and you pass away and you haven't thought through all the consequences. This is Rehan Alimohammad with another edition of Do You Know the Laws?